Good evening to everybody. Welcome to the class of the International Human Rights Law. And today that I am going to deal the African Court of the Rights of the Peoples, Human Rights and People's Court. That is the exact word. So that is, we can see on the screen. Yes, anyone can unmute and read what is there on the screen? Anyone can unmute and read. It is welcome to the African Court. That is written over there. Where it is there? It is in Arusha, Tanzania. Is it clear? Okay, without wasting the time, that I would like to go to the point. The African Courts on Human and People's Rights. So let us see that point wise, because it will deal the cases. It is the final court in the human rights in the African continent, because I told you that the regional courts are there. One is in Africa, that is in Arusha, then another is in Inter-America, that is there, and that is Costa Rica. And then for the European, there is Strasbourg, the European Court of Humans and People's Rights. Whatever the human rights violations would be there, these three regional courts will take into the consideration. Welcome, second Abal. So the African Court on the Human and People's Rights, how was the court established? What was the reason the court will be established? Then you see it, the African Court on Human Rights was established by the protocol to the African on Human People's Right and the establishment of African Court on Human People's Right. That the court protocol is there. The African Charter on the Human and People's Right Charter is the main African human rights instrument and set out the rights and duties relating to the human and people's right. So how the court is established? The court is established because of a charter. What is the charter? The charter is the African Charter on the Humans and People's Rights is the main African Human Charter. That is based on that thing, the court is established. For instance, if any university, public university will be established, there would be an act. The act would be there. With the act only, the public university will be established. Am I right, Saginapal?
Yes, Prof. Yes.
Repeat.
Yes, Prof.
Any public university will be established through the charter. For instance, you take the UDSM, there is a charter, act. And the Muzumba University, there is an act. And the MOKU, there is the Moshi Cooperative University, there is an act. And Sokoni, there would be an act. Whatever the public university would be there, there would be established with their act. So the charter established the African Commission, and this charter also established the African Commission on Human and People's Rights Commission, which is a quasi-judicial body that monitors the implementation of the charter. So the charter will establish the two. Number one, the court, that is the Human Rights People's Court. Number two, African Commission on the Human Rights People's Rights. Commission is there. And the commission would be there in the Tanzania. I told you already, the commission, the two offices are there, one in Dar es Salaam and another is in Dodoma. And which is a quasi-judicial body that monitors the implementation of the charter. So commission decisions are not binding, but the commission recommendation will be taken into consideration by the court, and the court decisions are binding. That is the human rights, the Human and People's Rights Court, which is there in Arusha, it is a binding. In 1998, the 34th ordinary session of the Assembly of Head of the State and Government of Organization of the African Unity, now the African Union, earlier is the African Unity, now the African Union, meeting in I don't know how do you pronounce it. Ouagadougou, Burkina Faso adopted the court's protocol. How do you pronounce this one? Sakina? Pronounce?
Yes. Yes, Prof.
Which I highlighted. How do you pronounce?
Oi. Oh. Burkina Faso. The first word I cannot pronounce it, but
Ouagadougou. Ouagadougou, Burkina Faso adopted the Code of Protocol. This protocol entered into the force in 25 January 2004, paving the way for the operation of the code. So the code is operated from the January 25, 2004 onwards. Okay. What is the court mandate? Which court? Arusha Code. What court it is? African Human Rights and Peoples. The African Court of the Human Rights and Peoples. So that is the, sometimes we can say tribunal also. But actually the wording they say the court. The court mission is to complement and reinforce the functions of the commission in promoting and protecting the human and people's rights, freedom and duties in African Union member states. The commission, being a quasi-judicial body, only make recommendations while the court make the binding decision. Yeah, I told you already that. The commission make the recommendation. It is not a binding, but the court make it is a binding, the decision. If the commission report is very exactly correct, then they will take an action against the person, those who violated the human rights, and that will be a binding decision. Because all the members of the African Union, they will see that the court decision would be followed, executed, or binding one. Is it clear? Say yes or no.
Kasam.
Sema.
Come
Second. I could not hear you.
up again.
Can I go ahead? Say, go ahead.
Yes, Prof. Yes.
Okay, I appreciate. So now let us see the next point. What is the composition of the court? Means constitution. And how many members are there, how many judges are there, and so on and so forth. And if you see this one, yes. The composition of the code is composed of the 11 judges. How many? Kumina Moja. 11 judges, nationals of the members of the state of the African Union, elected in an individual capacity. The judges are elected by the Assembly of the Heads of the State and Government of the African Union for a period of 6 years and may be re-elected only once. That means how many years that he could continue it as a judge of the African Court of the Human and People's Right? Yes? Speak. How many years a judge would be continued in the African Court of the Human Rights and People's Court? Human Rights and People's.
6 years.
In the beginning, it is the 6 years. If it is re-elected again
Yes.
6 years, the total number is
12 years.
only 12 years because the re-election is only once. Here it is given 6 years and may re-elected only once. That means he could serve only the 12 years if he or she will be re-elected. Is it clear? Say yes. Is it clear?
Yes, Prof.
How many judges are there in the African Court of the Human
11
Rights
judges.
People's Right Court?
11 judges.
11 judges are there, yes. For the purpose of the continuity, the intercepting judges are allocated a term of 2, 4, and 6 years. If thereafter they are elected, their second term will be for 6 years. See here, the point is here, for the purpose of continuity, the incepting judges are allocated a term of 2, sometimes 4, sometimes 6 years, and if they are after they are elected, their second term will be of for 6 years also. In turn, if any judge would be either died or what will happen, or he will be impeached, or he will be removed, or the termination is over, or the tenure is over at the time, there is sometimes the 2 years, 4 years, 6 years will be there, but it will be re-elected next time as the 6 years. That means not every judge will serve as the 12 years. Some may serve the 8 years, some may serve the 10 years, and some may serve the 11 years. Because 2 years, 4 years, 6 years are there. Is it clear?
Yes,
All
Prof.
judges, the president perform their functions on the part-time basis. All judges except the president. So, perform the function as a part-time basis. All judges are like a part-time except the president and who will perform the function of the part-time basis. The court meets 4 times a year in ordinary sessions, lasting 4 weeks each, and in extraordinary sessions as necessary. Means 4 times only they will meet it, and hence president only the full-timer, but the rest of the judges are the part-timers. Because they will sit only 4 times in a year. That is the reason. So now let's see the next point. Why it is not going down? What is the court jurisdiction? Can you tell me what is the court jurisdiction? Just use your IQ. Second of all,
Yes.
what is the jurisdiction of the African court? It is clearly given whatever the member states would be there for the African Union, they are all come under the jurisdiction. Simple question. The court has a jurisdiction over all the cases and disputes submitted to it regarding the interpretation and application of the charter, the court's protocol, or any other relevant human rights instrument ratified by the concerned states. All the states' jurisdiction would comes under the African court, humans and peoples. So now the advisory jurisdiction. The court may, at the present request of the member of the state of the African Union, any of the organs of the African Union, or any African organization recognized by the African Union, provided an opinion on any legal matter relating to the charter or any other relevant human rights instrument, provided that the subject matter of the opinion is not related to the matter being examined by the commission. So sometimes if it is not examined by the commission, then advisory jurisdiction also be there for the African court. Original jurisdiction and advisory jurisdiction. Then a contention of the jurisdiction, let us see. What is the contention of the jurisdiction? So contention, not contentious, not continuous, contentious jurisdiction. The court can deal with all the cases and disputes submitted to it. What submitted to it? They filed to it. It's more appropriate. To it in a concerning interpretation and application of the charter, the protocol and other relevant human rights instrument ratified by the state concerned. So, the states which ratified the convention, if any violation would be there, any one of the state in the African Union, then the action will be taken. And if any individual can file it, organization will file it, and NGOs can file it, our state can file it the case against the person, those who violated the human rights. So now let us see the amicable settlement. What is the amicable settlement? Can anyone unmute and read what is the amicable settlement? Here which I am highlighted. Quick.
Amicable settlement. The court also has jurisdiction to promote amicable settlement in cases pending before it in accordance with the provision of the charter.
Yes. According to the provision of the charter, in the suo motu, even the court can decide the case and see that the justice should be given. That is called amicable judgment. Means without hurting anybody's feelings, anybody's sovereignty, anybody's the rules and regulation of the particular country, and they harmonize it and they will see that justice will be done. So amicable settlement can be also does in addition to the original jurisdiction, in addition to the appellate jurisdiction. So that is the amicable settlement also be there. Now next point is, who can make an application to the court? State, individuals, organization, NGOs. So the African Commission on the Human People's Right, even a commission can also file a case. Or an organization also can file a case. Let us see that how it can be done. A state party to the court's protocol against which the complainant has been lodged at the commission. Generally, the person who has lodged a complaint at the commission will investigate it and send the report to the even the International Human Rights Commission, as well as you can file a case in the court of law if any violation should be there on the basis of the complaint of a individual or organization or NGO. A state party to the court's protocol whose citizen is a victim of a human rights violation If any person who is a victim of the citizen of the violation of the human rights, yes, even individual or organization or the NGOs can file it a case complaint to the commission. Commission will take up the issue and see that the justice will be done through the African court. Now let us see the African intergovernmental organization. State parties to the court's protocol with an interest in a case may be permitted by the court to join the proceedings. Who are the member of the states? If that state also be suffered the human rights violation, they can join, rejoinder. They can join and file a case, jointly and severally also. Then relevant non-governmental organization, there is a NGOs with the observer states before the commission, and an individual can institute the cases directly before the court. Even any individual, organizations, or NGOs, or the person observing states, even a state can file a case if any violations would be there in any country and where it is a member of that charter, that is the African charter, where this court is established by the charter. If the state party from which they come from has made a declaration allowing such a direct application, of course, the state should be a party to it, to the charter, then only the case will be entertained. So, what are the court's official language? Yes, anyone can unmute and read what are the court's official language? Which I highlighted here. Yes.
Yeah. The court's official language are the same as those of the African Union. The official language of the African Union are set out in the Constitutive Act of the African Union as being English, French, Portuguese, and Arabic.
These are the four languages would be there where it can be undertaken. And if any decision would be there, it will be translated into the four languages: English, French, Portuguese, and Arabic. At least one should have to know the one international language. Of course, everybody knows English, but if you know the French also, it's well and good, because you can speak French in some other countries, but mostly the English and French will be spoken in the most of the countries. How do you file an application to the court? Yes, cases shall be submitted by post. Even you need not to go over there. Even you can submit by post, by the email, by the fax, or a courier to the registrar in terms of the Rule 25 and Rule 34 at the seat of the court in Arusha, Tanzania. So the Rule 25 and 34 should be followed over there whenever you send a complaint to the registrar of the African Court of Human and Peoples. At that instant, the registrar has custody of the seal and official stamp of the court with which to officially acknowledge the receipt of any case submitted. And he will definitely acknowledge with the official seal that they have received the case and complaint. The term registrar here is used in the widest meaning. Generally, the registrar means he is an administrative officer, because any case would be filed over there. We cannot file against the Vice Chancellor or the President, but we will file against the registrar and who maintain the administration of the court. So here the receipt when is submitted. The term registrar here is used in the widest meaning, that of a registry office rather than the person of the officer. For the absence of the person, the office will continue function. Of course, if anyone would be there on behalf of the registrar, can also acknowledge and make the stamps and seal over it that the candidate has submitted it and they received it. That is an acknowledgement. One has to send the court's registry a signed application written in one of the court's official language. So the court's official language, I told you that English, French, Portuguese, and Arabic. In any one of the language that it can be, application could be sent. What are the conditions of sending an application? When you want to send an application, how conditions should be there? Number one, for the application by the individuals and NGOs or the applicant must be, number one, disclose the identity of the applicant. And who is the applicant? The identity will be disclosed. That means name, father name, age, place, and district, country or province, and the PIN code. These are clearly written over there. Even where the applicant has requested anonymity, Even where there is applicant has requested anonymity, sometimes no, people will fear it if their name should not be appeared over there. Otherwise, if the name will appear over there, then the society people will tamper him, or he'll make the harassment to him or her. Number two, comply with the Constitutive Act of the African Union and Charter. Yes, what is the Constitutive Act of the African Union is there, and what is the Charter? Based on that, then the Arusha Court is established. So, complying all the constitutional acts in the African Union and the Charter articles should be followed. Number two. Number three, not contain any disparaging or insulting language. And the language which could be used over there should not be disparaging, and the insulting language should not be used over there. Fourth, not the based exclusively on news disseminated through the mass media. Only the mass media basis, you are not supposed to file a case unless until you really investigated and found that there would be a mass violation of the human rights is there in particular state. Then only we can make it out, but not on the mass media. Is it clear? Read the fifth one. Read the fifth one. Anyone can unmute, read the fifth one.
Be filed after exhausting local remedies, if any, unless it is obvious that this procedure is unduly prolonged.
Yes, that means we filed after exhausting the local remedies. You need not to directly file to the African Arusha, the African Court of Human and Peoples. No. File a case in a lower court. Either you can say district court, or if the jurisdiction will not be there for the district court, then you can file in the high court. And the high court, if you are not happy by the decision of the high court, then you can approach the Court of Appeal in Tanzania. At the last, when you exhausted all the local remedies, then you have to file to the Arusha court. So that is the thing. Be filed after exhausting the local remedies. Means local in the sense national remedies. Arusha court is not a national court. It is a regional court in the entire African continent for the member states. If any, unless it is obvious that this procedure is unduly prolonged. Suppose the procedure is very unduly prolonged over there at the time, very rare cases, you can directly file a case in the Arusha. But the court will see it. For this matter, why do you want to come over here? If it is really a prolonged matter to be there, then court will entertain it. If not, the court will decide. Please file the case in the local domestic court and the municipal courts. Number 6. Unmute and read number 6 point. Anyone?
Be filed within a reasonable time from the date local remedies were exhausted, or from the date set by the court as being the commencement of the time limit within which it shall be seized with the matter.
Yes, that means be filed within a reasonable time. See, if a violation of the human rights is there this year, can you file a case after 10 years? Answer, no. Be filed within a reasonable time. Okay, 10 days, 15 days, 1 month. There is more. From the date local remedies were exhausted. When the local remedies are exhausted over there, means either the district court or the high court or the court of appeal, and where you could not succeed. From the date set by the court, when the court has decided that case, apex court, as being the commencement of the time limit, from that date onwards the time limit will start, within which it shall be seized with the matter. So the date of the decision will be taken into consideration, either the high court or the court of appeal. When the judgment is made over there, from the date of the judgment, the time limits will start, means law of limitation will start. So that is now the 7th one. Not raise any matter or issues previously settled by the parties in accordance with the principle of the Charter of the United Nations the Constitution Act of the African Union, the provisions of the charter of any legal instrument of the African Union. Not raise any matter or issue previously settled by the parties in accordance with the principle of the charter. If any matter will be not settled over there earlier, or if there is matter which arises, generally the matter will be arises through the charter only. The charter matter only can be entertained. But in case, sometimes, other than the charter, if any other which is not covered by the charter is, any violations are taken place, yes, at the time, the Constitution Act of the African Union, the provision of the charter or any legal instrument of the African Union, they can use any instrument, either African Union Constituent Act or the African Charter or any other instrument which will be protecting the human rights violation, it can be used over there. Not raise any matter or issue previously settled by the parties in accordance with the principle. If suppose the previous settled matters are there, but if there is injustice happened over there, yes, it can be reviewed within the principle of the Charter of the United Nations. Yes, it can be entertained. If any injustice really happened, because a gross negligence would be there on the part of it, then it can be undertaken by the African Charter. So, these are the functions of the African Charter. African courts are there. In addition to the above requirements, application by the individuals, even the individuals and the NGOs should indicate, and this also applies to application by the entities other than the individuals and NGOs. Means a person can approach to the African court by post, by email, by telex, by any other means, but the language should be in the four. What are the four languages? Anyone? What are the four languages?
English, French, Portuguese, and Arabic.
Good, appreciate Sakina. Appreciate the memory. Yes, the four languages we can, any language that you can entertain the case. Now let us see some other conditions are there. Number one, the names and addresses of the person designated as the applicant's representatives. Suppose the applicant representative would be there and who would like to file a case, and the total details of the person should be given over there. Number two, a summary of the facts of the case and of the evidence that will be adduced. The material facts should be mentioned, and what are the supporting documents should be there, and that should be mentioned. If the person or document or record or any other which are relevant to the case. Number three, clear particulars of the applicant and of the party and the parties against whom the applicant has been brought. So, to whom against that party, the clear particulars should be given over there. To whom the action will be taken against him. Number four, specification of the alleged violations. What are the violations alleged are there? It should be specifically mentioned. Is it a sexual abuse? Is it a slavery? Is it a harassment? Is it a pornography? In any way that abuse was taken place or violation of the human rights are there. So the fifth one, evidence of the exhaustion of the local remedies. Yes, first and foremost, you exhaust the local remedies, and if any ordinary delay would be there, okay, then at the time you can approach to the African court. Provided African court would be satisfied over there, because he did not approach the local remedies, but he is thinking that the inordinate delay would be there. By that time, the justice will not be prevailed over there. In that case, that it can be entertained. The sixth point, the order or injunction sought. What is the order? What is the injunction? Of course, the African court's decisions are binding. The commissions are only quasi natural, and hence it's only suggestion, but the suggestion of the commission will be taken into consideration by the African court and it can upheld also. So whereon an applicant or his or her own behalf or behalf of his victim wishes to be granted reparation, the applicant should be include the request of the reparation. See here, on behalf of the applicant, because he is not over there, because he is a country of different nation at the time, and he wants to go, and it will be represented by a person to whom that he allotted the case. So what is the applicable law for the court? The court applicable law, can you follow the municipal law? Yes, sometimes we follow the municipal law because what the law is prevailed over there and what the instrument will say. If the instrument will clearly mention the offense as well as the punishment, then the charter rule will be followed. Charter articles will be followed. The court shall apply the provisions of the charter and any other relevant human rights instrument ratified by the state concerned. So the state is ratified by any other human international conventions, protocol, declaration, charters, or treaty. Yes, it can be used over there. Suppose the charter is silent. Think that charter is silent. Then we can use the common law. This is my view. But generally, charter will deal everything in a clear-cut manner. If one charter will not deal it, at least another protocol or another treaty or where the state is ratified another instrument, definitely it will cover it. But in generally, when we say the municipal law, when the statute is silent, common law will prevail. I'm speaking about the common law countries. When the statute is silent, then the common law will prevail. But here, charters definitely will make coverage. In one form, in another form, in the different treaty, or the protocol, or the declaration, in any way that will be covered over there. So, they will also depend upon the charter or any other instruments where the state is ratified those instruments. So, the charter provides here, the cursor is here. Can you read the cursor is here. Okay? Read. I said read.
The Charter provides that the source of law that applies for the monitoring of the implementation of the Charter are international law on human and people's rights, particularly from the provision of various African instruments on human and people's rights, the Charter of the United Nations, the Charter of the Organization of African Unity, now the Constitutive Act of the African Union, the Universal Declaration of Human Rights, other instruments adopted by the United Nations and by the African countries in the field of human and people's rights, as well as from the provision of various instruments adopted within the specialized agencies of the United Nations, of which the parties to the Charter
Charter
are
are the
members.
members. So here it can cover anyone, either charter or the treaty, bilateral, multilateral, declarations, protocol, special agencies, and where the state is the party to it. By any other means, it can be covered. If one is not covered over there, they will see the Constitution Act of the African Union. If it is not covered over there, they will see the UN Charter. If it is not covered over there, Universal Declaration of Human Rights. If it is not covered over there, any other instruments which is followed by the African countries on the human and people rights, definitely it will be adapted because the country is ratified that international instruments. So within the specialized agency, even the specialized agency like ILO is there, WHO is there, UNICEF is there. These are all the specialized agency, and whatever the specialized agency will, where the state is a party to it, yes, that also we can consider because specialized agency will be made with the permission of the United Nations, with the sanction of the United Nations, whose the parties to a charter are members. So that is the whole idea behind the charter provides. So what is the nature of the court's findings? Here in the sense decision. When the court finds that there has been a violation of the human rights and human and people's right, okay, it will issue appropriate orders to remedy the violation, okay, sanction, declaration, including the payment of the fair compensation or reparations. Both the things. Either fair compensation will be paid over there, In sometimes community service also will come. I don't know what exactly the reparation mean. In the way we can make it out. Reparation. Reparation. The action of making amends for your wrong one has done by providing a payment or other assistance to those who have been wronged. Even a community service. Either the payment or reparation. Both the things will be allowed over there. The action of making the amends to a wrong one has done by providing a payment or other assistance to those who have been wronged. Any other assistance, even that can also becomes when you say the reparation. So in any way, that is the compensation will be paid, and he will be put behind the bar also. But merely putting the behind the bar, the victim is not going to get anything. Hence, compensation of money, damages should be awarded over there. If the damages could not be make it over there, at least assistance should be given. The next alternative, the service should be given over there. They're taking care of the families. Reparation also be allowed. In case of the extreme gravity and urgency, and when necessary to avoid the irreparable harm to the person, the court can adopt the provisional measures as necessary. So, depending upon the necessity and what the grave violation is there, then definitely they will even send the UN peacekeeping force through the sanction of the Security Council. An example of this situation which necessitates the adoption of the provisional measures is when death sentence is to be executed and the appeal process has not been exhausted. Okay, when the question comes over there, when a situation of the hanged to death has come over there, at that instance, first and foremost, your due process should be followed. Appeal process has not been exhausted. Appeal process should be exhausted over there. Then only it can be implemented. So, such a situation, they can adopt the provisional measures. How long does the court take to render a judgment? Like a civil cases which are happening over there, or do they have the time management? The court gives a judgment within 19 days, 90, of having completed its deliberations. So 90 days, the matter should be settled. But you may say that, sir, the court will sit only 4 times in a year. No, sometimes a special sitting also be there. When the emergency comes over there, the special sitting can also be done. So within 90 days, when the case is filed over there, the case should be disposed. 90 days means 3 months roughly. In its judgment in final, not subject to appeal. Its judgment is final and not subject to appeal. But once the Arusha court has given the decision, that is the final. And there is no question of appeal because that is the highest court in the African continent. Regional court. Is it clear? Say yes.
Yes.
Good. However, in the light of new evidence, which was not even within the knowledge of a party, at the time the judgment was delivered, a party may apply for the review of the judgment. Of course, in some cases, no. A new thing has come, exhausted, new thing have come up or cropped up over there, then they will ask for the review. But only that thing, otherwise, there is no question of appeal is different, review is different. Is it clear? Say yes.
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 Now let us see that. What are the relations between the African Court and Commission? I told you already, Commission is a quasi-judicial body and the binding is only a recommendation it can do. But when you come to the court, it's the binding one. Yes. If they don't, there will be contempt of the court also if any other person violates the decision of the court. The pursuant to the Article 2 of the protocol, the court is established to complement the protective mandate of the commission. So what is the mandate of the commission would be there? That mandate or suggestion can be followed by the court because under the Article 2 of the protocol. The African Commission can bring a cases to the court for the latest consideration. Yes, Commission will make the investigation and the file a case in the African court. Yes. Based on the complaint by the individual or by the organization or by the entity or by the NGOs. In certain circumstances, the court may also refer the cases to commission. Yeah, sometimes the court will see, please investigate this matter because there is something fishy. So the commission go to the particular place and take the views of the people, community, and the entire village, and they will come with the report and request the opinion of the later when dealing with the admissibility of the case. If they want to admissibility of the case also, they will assign the work to the commission to see whether the allegations were made is genuine or not. So they will make an investigation. Then only they will admit the case. In certain circumstances, the court may also refer the case to the commission and may request the opinion of the later when dealing with the admissibility of the case. Yes, in the admissibility of the case, you will take the opinion of the commission. The court and the commission have met and harmonized their respective rules and procedures and institutional their relationship. So the commission as well as the court both will go together. They harmonize the things, the rules and procedures, and institutionalize the relationship, and thus they will decide the cases. In terms of the rules, the commission and the court shall meet at least once a year to discuss the questions relating the relationship. So at least once in a year they have to sit each other, who? Court and commission, and to resolve any matter is concerned which is not that much clear in both their sense. So now let us see does court deal criminal matters? Human rights violation is a criminal matter. As at now, African Court on Human and People's Right had no jurisdiction to deal with the crimes such as a genocide, crimes against the humanity, war crimes, but there is a project to have a full African court with the extended jurisdiction. So, genocide, there is a different court. And extreme humanity, there is a different court. War crimes, a different court. But it is only particularly the human rights violations are there it can entertain. In fact, the Constitution Act of the African Union provides for the establishment of the Court of Justice and the African Union as principal judicial organ of the African Union to settle the dispute over the interpretation of the AU treaties. If any AU treaties are there, the Court of Justice of African Union will take care of it. A protocol is set up by the court was adopted in the Maputo, Mozambique in July 2003 and entered into the force 11th February 2009. The court was, however, never operationalized because the Assembly and African Union decided it should be merged with the African Court on Human and People Rights. A different court is made over there in the Maputo. That is the Court of Justice of the African Union. But it is not materialized over there. But they say, instead of having another court for the criminal offences or any other offences which is not covered by it, let it be, jurisdiction will be given to the African court itself. The court was, however, never operationalized because the Assembly of the African Union decided that it should be merged with the African Court on Human People's Right only instead of having a different court. Only one court may entertain such a cases if it is needed over there. So, the court was, however, never entered into the force. February 2009, the court was, however, never operationalized because of the Assembly of the African Union decided that the matter should be given to the Human and People's Rights. The forum, African Court of Justice and Human Rights, that is ACJHR. Underlying the decision was uncertain that the growing number of the AU institution which the AU could not afford to support. See, human right violation, when you say sexual abuse, when you say the sexual abuse, naturally the criminal act. Because it's an abuse against the human body. When you abuse against the human body, yes, it is a criminal act. And such a thing also should be given the Humans and People's Right Court be given such a jurisdiction to entertain it. Okay, it's the purely and different nature of the, yes, we can go for instance, genocide is there. Yes, for genocide, we can go for the International Criminal Court, The Hague. Yes. Now, the Rohingyas are killed many of the Islamic people in the Burma. At that instance, the case is filed in the International Court of International Criminal Court because genocide. It will not come under the Asian because the Asian will be covered under the because African is there, Europe, Asia. Yeah, it come under the Asia, Europe only. That country is hanging, not inter organizational because India will not come under the Asia. Sorry, India will not come under the Africa. Is it clear? I believe that the European court will entertain in such a case if any human rights are there. Okay, the countries where it is attached, depending upon the charter. Yes, charter, depending upon the charter, with the charter, who are the state members, and for them it is applicable to them. Applicable, that court is applicable to them. So here they say it could be entertained only certain matters, but genocide is concerned and humanitarian war conflict is concerned, yes, it will be deal with the International Criminal Court. If it is a state to state matter is concerned, it is the International Court of Justice. The application must be within 6 months after that party acquired the knowledge of the evidence discovered. The court may interpret its own decision. 6 months time will be given over there to entertain such a case. What are the relationship between the African Court and Commission? Yes, I told you, relation. Pursuant to the Article 20 of the Protocol, it is established a complement to the protective mandate of the Commission. Commission is only the quasi nature, it's not a binding, only give the suggestion. The African Commission can bring the cases to the court on the complaint of the people to the African Commission, and the cases will be filed by the court, by the Commission for the latest consideration. We read it, it is a repetition. In certain circumstances, the court may also refer the cases to the Commission to inquire whether it is a complaint is genuine or not. So the Commission will approach to the village and take the opinion of the people, and they will give the authentic report to the court. The court and the Commission have met. They sit together and they will harmonize their respective rules. The cursor is here. And the procedures, and they institutionalize the relationship. And how it can be dealt, it can come to a conclusion by following, at least sitting once in a year, who Commission as well as the court. In terms of their rules, the Commission and the court shall meet at least once a year to discuss questions relating their relationship, and that would be the way the Commission will work in Arusha. So today we dealt how it can be dealt, and as you've seen that we have the 15 question. To my knowledge, it is a still 5 minutes are there. It is a 13th question, if I am not mistaken, among the 15 questions which I have given over there. Let me check it. 15 questions which I have given for you. Oh, it cannot be traced out. Yeah, it is one of the questions where how the role of African court, Human and People's Court, will protect and promote the human rights violations. Justify your answer with any decided cases. At least you have to case law, 1 or 2 case law, you have to cite it. But not write the entire case law, but only the gist can be made it over there. And your answer, I told you, depends upon the marks